Hello everyone, welcome to Steno Aspirants. I am Akshay and I am going to dictate you Rajasthan High Court judgment containing 720 words at the speed of 90 words per minute. The dictation will fluctuate between the speed of 85 to 95 words per minute, so get ready. 3 seconds. Start. Contention of learned counsel for the appellants is that order dated 25/1/2018 protected the writ petitioners against confirmation of auction sale proceedings only till hearing of the stay application stopped. The case was listed before the DRT on subsequent dates, but no stay was granted, though hearing of stay application had taken place. However, the case was adjourned stop. Therefore, the protection under order dated 25/1/2018 passed in the writ petition came to an automatic end stop. This was the bona fide understanding of the order of the court by the authorities of the bank, which led them to proceed with the auction of the property in subsequent auction proceedings stop. In order to persuade this court to accept the aforesaid submission, learned counsel for the appellants has referred to various orders passed by the DRT from time to time stop. Learned counsel for the appellants further argued that the respondents' writ petitioners were not entitled to protection as granted to them by order dated 25/1/2018 because the respondents' writ petitioners were not repaying the debt despite repeated opportunities, and the writ petition was filed on incorrect facts in order to somehow make out a case that because of non-sitting of the DRT, writ petitioners had to approach the writ court seeking protection till decision of stay application stop. Further argument is that though application for stay was taken up for hearing, but no interim order was passed in favor of the writ petitioners by the DRT stop. It has also been argued that the writ petitioners themselves were not fully satisfied with order dated 25/1/2018 passed in the writ petition. Therefore, they preferred DB Civil Special Appeal (writ) number 444 oblique 2018, which was disposed of on 3/4/2018 with the observation that the appropriate remedy was to apply for review stop. Thereafter, the writ petitioners filed SB Civil Review Petition number 114/2014 on 24/2018, wherein notices were issued and the case was pending stop. Therefore, it is contended that even at the instance of the writ petitioners, order dated 25/1/2018 was assailed and review of the writ petitioners was also sought stop. In this background, the action of the concerned bank officials in proceeding with the auction, confirmation of sale and issuance of the sale certificate cannot be said to be an act of disobedience so as to constitute contempt of the court stop. Learned counsel for the appellants in both the appeals have raised a common submission that while deciding the contempt petition, supplementary directions have been issued which is not permissible in law in view of the dictum of the Honorable Supreme Court in the case of J.S. Parihar versus Ganpat Daggar and others, bracket 1996, 6 SCC 291 stop. It is also argued that an error of law was committed in relying upon the judgment of the Honorable Supreme Court in the case of Jehal Tanti and others versus Nageshwar Singh bracket dead through LRs bracket 2013 14 SCC 689 because in that case the matter was ultimately remanded to the court for fresh disposal stop. An attempt has also been made to convince the court that order dated 25/1/2018 passed in the writ petition was not justified in law and in view of several judicial pronouncements of the Honorable Supreme Court in catena of decisions. Writ court ought not to have intervened with the auction proceedings and for this purpose judgment rendered by the Honorable Supreme Court in the case of authorized officer State Bank of Travancore and another versus Matthew KC bracket 2018 3 SCC 85 has been relied upon stop. It is also submitted that the observation of the learned single judge while holding the appellant's bank officials guilty of contempt for filing an application for withdrawal oblique recall of sale certificate before the recovery officer is also not justified in law because as per the provisions of the Surface Act, the proceedings initiated under section 13 of the Surface Act read with the securitization and reconstruction of financial assets and enforcement of security interest bracket start casual registry rules 2011 bracket close by the authorized officer are separate and independent from the recovery proceedings. Therefore, the proceedings of the authorized officer cannot be undone by the recovery officer full stop. Undone UNDONE stop over.